May it please the Court, my name is Peterson, Petersen, and I am counsel for the applicant in these proceedings, Mr. Hugh Grant. The applicant, Hugh Grant, was summarily dismissed on Friday the 1st of January and is now seeking remedies for wrongful dismissal. To please the Court, I will begin with our first submission, Submission 1, Notice of Termination. Under Section 117 of the Fair Work Act 2009, an employee must have given the employee written notice of the day of termination, which cannot be before the day the notice is given, for the termination to be valid. In consideration of the period the applicant was employed for, 4 weeks' notice should have also been given as outlined in the Fair Work Act. This notice does not, however, apply in cases of serious misconduct. In place of notice, the employee may make payment in lieu of notice, which must be at least the amount the employee would have received had they continued their employment to the end of their period of notice. We submit the applicant did not receive written notice of the day of termination before the date of termination, nor did the applicant receive either 4 weeks' notice or the 4 weeks' payment in lieu of notice which they are entitled to. The Police Court will move on to our second submission, age discrimination. Under the Fair Work Act 2009, an employee must not discriminate against an employee based on their age. Additionally, Part 4E of the Anti-Discrimination Act 1977 specifically forbids compulsory retirement ages. As in Qantas Airways and Christie, the employer must show that mandatory retirement is an inherited requirement of the position to avoid liability for this age discrimination. In this case, the applicant's job title is that of mine manager. The applicant spends most of his time in his office completing occasional inspections of the mining operations. Under the Mining Safety Act 1111, underground mine workers must retire at age 60 and are defined as a person who works on a regular basis in an underground coal mine. We submit the applicant does not meet the definition of an underground coal worker, therefore the applicant is not subjected to the mandatory retirement rules under the Mining Safety Act 1111, and the respondent is liable for age discrimination. Pleasing the Court will move on to Submission 3, terminating for future breaches. As in Blythe Chemical and Bushnell, an employer must not terminate for future possible breaches. Whilst production is expected to be reduced by 10%, Clause 11.3 of the applicant's contract of employment also states that if an employee's performance does not meet agreed upon KPIs, their employer may be terminated after due counselling process. Therefore, the respondent cannot terminate for future possible breaches, and we submit that even when the applicant fails to meet KPI targets, termination may only occur following the due counselling process. Pleasing the Court will move on to Submission 4, summary termination. Summary termination may only occur where there's been a fundamental breach. Where an employer is aware of the breaches but has ignored them, they waive their right to terminate based on those breaches. And as previously stated, an employer may not terminate for breaches that may occur in the future. Each of the respondents' claims of serious misconduct accounting to summary termination will now be addressed. The first misconduct concerns the applicant's refusal to introduce lesser qualified workers on temporary visas. This is an old issue, and the respondent did not act upon it. As in McCasker and Darling Downs Cooperative Bacon Association, the respondent has waived their rights to terminate based on this breach as they were aware of the misconduct but did not act upon it. The second alleged breach is in regards to the applicant's reluctance to reduce staffing levels by 20%. The applicant has clearly raised workplace health and safety concerns regarding these workplace changes and has been in consultation with the Australian manager for the respondent regarding these safety concerns. Under the applicant's employment contract, there is an obligation to consult on workplace changes. In this instance, the applicant has not refused to make these changes, but is in consultation with his superiors. Summary termination is only applicable in the most serious of cases, and for it to be upheld, there must be gross or serious misconduct. As in Laws and London Chronicle, an isolated act of disobedience is not sufficient grounds for summary termination, and this reasoning was upheld in Bruce AWB Limited. In consideration of the facts, we submit the applicant has not disobeyed directions but is seeking consultation as per his employment contract for safety reasons, and the fact that if he did refuse, it would constitute merely an isolated act of disobedience. This alleged breach is not sufficient grounds for summary termination given the facts. Lastly, the third alleged breach pertains to discussing confidential business matters with the union. Whilst breaches for dishonesty are usually upheld by the court, the breach must be proven. The applicant made the union aware there was an issue, but did not divulge any details of the matter. As in Del Castle and Oars and Artemis Australia, confidentiality must be held within the terms of employment. The respondent has, however, failed to show that the applicant breached confidentially in their discussions with the union, as the applicant did not disclose any details of the matter. Therefore, we submit the applicant's conversations with the union did not constitute a breach of confidence and is not sufficient grounds for summary termination based in a case of serious dishonesty. Pleasing the court, we'll move on to our fifth submission, submission 5, wrongful dismissal and unfair dismissal. Where wrongful dismissal has occurred, as demonstrated in this case, the employee may seek remedies of common law for either reinstatement or damages. As per section 385 of the Fair Work Act, where it may be sufficiently shown that the dismissal was harsh, unjust, or unreasonable, the employee will be considered as being unfairly dismissed. In determining this, whether there is a valid reason for dismissal, whether the person was notified, whether the employee had the opportunity to respond, and whether the employee's dismissal related to unsatisfactory performances and they had been warned of such before their dismissal, are all relevant in determining unfair dismissal in this case. In addressing these points, the respondent has already been shown to have not to have valid reason for dismissal of the applicant. The respondent has been shown to have failed to give adequate notice of termination. The respondent has not also adhered to the grievance procedures within the applicant's contract of employment. As in Van Efferen and CMA Corp Limited, it is reasonable to consider that had the respondent followed the correct grievance procedures, it is likely the applicant would not have been dismissed. The applicant subsequently has not had the opportunity to respond to their dismissal, and the respondent cannot terminate for future breaches. And if or when the applicant fails to meet targets in future, termination may only occur following a due counselling process. Where the dismissal is shown to be unfair, as demonstrated in this case, the employee may then seek suitable remedies. Pleasing the court, we move on to our final submission, submission 6, remedies. Where the termination is deemed as unfair dismissal under the Fair Work Act 2009, the applicant pursues reinstatement or compensation. Where the termination of the contract is a breach of common law, the applicant pursues damages for loss of wages, remuneration, loss of superannuation, other such entitlements, and expenses for seeking further employment. Where the summary termination is upheld, the applicant should receive at least in minimum their payment in lieu of notice. The applicant also seeks compensation for the age discrimination committed by the respondent. With our thanks to the court, the counsel for the applicant now rests.